Thank you, Mayor. During verbal discussions with council members in preparation for this, a lot of inquiries regarding the code enforcement cases regarding DeBary Plantation, and thought that it would be a good time to brief the City Council on the code enforcement. Since you all don't participate in the code enforcement briefings, I do want to show you some of the evidence that's been presented at the code enforcement, the results from the code enforcement, and some of the results after the code enforcement. I am going to take this opportunity, as I usually do, to update on various issues on how the stormwater process works. It's always good to make sure that everybody understands how the stormwater works, what the city's responsibilities are, what St. John's Water Management District responsible is for, and really kind of explain the roles and responsibilities. There's a lot of misinformation out there and understanding of how the stormwater system works. And if you don't mind, the first 3 or 4 slides I'll go through just explaining some of the stormwater issues here in DeBary that, and who's responsible for what. So not many folks know that, and when we use the term the state of Florida really owns all the water in the state, other than the federal government where there's some federal there. But generally we use the term the state of Florida owns all the water in the state. And the St. John's, in 1972, the state of Florida created these water districts, and there's 5 of them. St. John's Water Management District handles Central Florida and Northeast Florida. And they are responsible for all stormwater, for all the engineering and design, the permitting, the construction, and the operation and maintenance control for the entire district. And no development comes into this city and gets approved by this city unless they have their engineering and design approved and scrutinized by the engineers of the St. John's Water Management District, and that the St. John's Water Management District issues that particular permit. Once that permitting is done, then the city in their development of developments that come in, then the city can issue a development order, but only once they get the permit from the St. John's Water Management District. As you recall, last meeting we had a future land use. You see concepts designed with the stormwater ponds on there. Well, those are just approximations. And if you had done the zoning and everything else, the developer would have to go through a significant amount of engineering and design for the stormwater system, a lot of testing, geotesting, and technological testing, and then they would have to get their permits. And so the ponds that you see in those concepts might not necessarily be the right size, shape, and they could adjust depending on the engineering. And so that's an extremely important step for people to know, that the city of DeBary does not approve any engineering and design for stormwater. It does not permit stormwater. It does not control the construction phase of stormwater, and it does not control the operation and maintenance entities in stormwater. All of these things are controlled by the St. John's Water Management District. Every operation, every construction, and there's 2 phases to the St. John's Water Management District. There's a construction phase and an operation and maintenance phase. And so when the permitting is issued, then the construction starts. St. John's Water Management District oversees that construction either through themselves by inspection or through a private engineer. As you know, state of Florida allows private engineers to be inspectors. And then they inspect it, and then they issue a certificate of completion. Once that certificate of completion is done, then the operation and maintenance entity that's been designated during the application process then takes over from there and is responsible for the operation and maintenance of that system in perpetuity. And I'll show you that statute that governs that. So you're going to hear the term through this presentation, operation and maintenance entity, or O&M is the acronym. The O&M phase is the operation and maintenance entity that's responsible to operate and maintain that system. Our city's responsibilities is that we do the code enforcement for operation and maintenance. And typically, the relationship for this operation and maintenance and construction, again, is with the developer and HOA and directly with the St. John's Water Management District. None of this involves the city permits, city's inspections, or city anything. This is the St. John's Water Management District relationship with the developer/HOA or the St. John's Water Management District. We also have the responsibility of being an operation and maintenance entity on the emergency stormwater management system that we built. That's an independent system that serves our entire city. And also we're the owner and maintenance entity for all the subdivisions that were built prior to 1980s. Back in those days, all those subdivisions prior to 1980, the subdivisions were created and the government took over the stormwater operations. But since 1980s, the philosophy of local government is to, if they want to, developer wants to give the streets public and the right-of-way public, is to turn the stormwater operation and maintenance to the homeowners association. And that's common practice throughout most of the cities in the state of Florida. And you see some recent activity also with, you may see some articles in Venetian Bay and some other cities that show that the HOAs are responsible for their own stormwater maintenance systems. This is our DeBary's emergency stormwater system, and you've seen this many times. We do collect a stormwater fee. One of the things that folks ask all the time, I pay a stormwater fee. The city should take care of all the stormwater in the entire city, and that perception is absolutely false. The city only takes care of a certain portion of the stormwater systems in DeBary, and so when we talk to folks about our stormwater fees, our budget, 30% of our budget goes towards salary and benefits and stormwater fee. 40% goes to debt service, and back in 2007 and 2008, the city borrowed money to build our emergency management system. And for folks' reference, the last 15 years, the city spent almost $32 million, both in stormwater fees, state appropriations, and FEMA grants, and everything else. We spent $32 million in building this emergency stormwater system. And as a result, Hurricane Ian, when we got 20 inches of rain in 24 hours, we only had one home flood, while other cities had hundreds and hundreds of homes flood because of their inadequate stormwater emergency management system. And so the rest of the 30% goes to operations. Some of that goes to maintenance, like, for example, we just purchased 2 new pumps at DeBary Plantation. We purchased a new pump at Quail Lake. We updated those because they're approximately 15 years old, so they can operate efficiently. Those comes out of stormwater funds. We also just approved the James Pond Station. Those also come out there, so we enhance our emergency system. And then, obviously, some of that money goes to our city operation and maintenance responsibilities as well. We designed this particular map for education purposes of the different factors in the city of DeBary. There are 3 basic factors here in which we look at. First is the public streets and private stormwater, and that's post-1980s. All subdivisions that come through since 1980s, if the developer wants public streets and public sidewalks and public right-of-way, and the stormwater is turned over to the HOA, and the HOA assumes the stormwater systems. And those are the areas in blue. Those are DeBary Golf and Country Club you see on the right. And you see some sprinkling of green in there. Those are private gated communities within DeBary Golf and Country Club. But also Springview Woods, Rivington, the Junction, Main Street, all will be public streets and private stormwater. And that is based upon the election of the developer. And when the developer wants public streets, we require them to have private stormwater. All the green that you see there are private, our communities are private streets, private stormwater. And so you can see there that Orlandia Heights, which is right above Springview, is private streets, private stormwater. St. John's Estates, which is just to the west of that. One subdivision that came in after the 1980s is Riviera Bella. Riviera Bella chose to be a gated community with private streets and private stormwater. And so the developer chose that because he wanted that to be able to sell those particular properties, which he thinks that was the best market. And so 36% of all homes in DeBary are private streets and private stormwater. Only 18% of DeBary's population homes are public streets, private stormwater. All the areas in white are all areas that were built prior to 1980s, and that was the development standard. As I said before, is that these developments came in, and the city standard at that particular time was to approve those developments and take over the stormwater for those there. That's Glen Abbey, Summer Haven, Woodbound Lakes, and all the older areas in DeBary that were built in the 50s and 60s. And that's about 46% of the homes. This will give you that snapshot. Every future development that comes into DeBary that wants to do public streets and public sidewalks will be responsible for their own stormwater. The developers are required by law to create a homeowners association, and as that development fills up, the developer weans himself off the HOA. My understanding is that Riviera Bella, that particular developer now, since it's almost completely built out, is now off the HOA, and the HOA is now completely occupied by the residents. And they are, by law, a successor of the developer, and they take over from the developer and make sure that that subdivision is operated efficiently and effectively. So these are one of the things that we talk about with St. John's Water Management District, and this is from their administrative code. And a lot of the folks that don't understand, they understand the permitting, they understand there's construction, they understand there's inspection, but then the second phase is the operation and maintenance entity, and who's responsible to maintain that stormwater system going forward. And these are two of the governing administrative codes of this St. John's Water Management District. Basically, it says the permit authorized construction and alteration must be converted to an operation and maintenance phase once the construction and alteration has been completed. And so this is the administrative rule that requires St. John's Water Management District to finish when they issue the certificate of completion, is then to move into the operation and maintenance phase. They control the title of the operation and maintenance entity, and they make sure that's the governing entity that makes sure the operation and maintenance is done properly and maintained. Also on the other section there on paragraph 2, the operation and maintenance entity or entities, it can be two or multiple ones, shall remain liable for compliance with the terms of the permit, which means in good operation and good maintenance condition, in perpetuity, unless it is transferred. And then usually transferring a stormwater operation and maintenance responsibilities is dedicated at the plat. When you approve the plats, there are dedications in there, and those plats will dedicate typically streets and sidewalks. If they want to be public, they'll dedicate those to the city. But also if they want to dedicate the stormwater, and if the city approves it, you can accept the dedication of the stormwater system at the time of plat. Or generally, it's also done at a separate agreement. And they can come in with an agreement, and the city can approve a special agreement. But there has been no dedication. All the plats in DeBary Plantation do not dedicate any stormwater systems to the city, and nor has there been a separate agreement. And so it's pretty clear at this particular point in time that DeBary Plantation is the owner and maintenance entity for this subdivision. And so there has been no filings with the St. John's Water Management District of any dedicated plats or separate agreements. And if you go on their particular website, you can see every transaction of every permit in DeBary Plantation, and there has not been any changes to the operation and maintenance entity. This is the land development code in the city that gives us the authority to enforce the code enforcement. It says, again, the responsible legal entity shall properly operate and maintain, repair, replace any stormwater management system and facilities, including without limitations. And you can read down there the retention areas and ponds, berms, control structures, weirs, pipes, ditches, swales, gutters, inlets, manholes, outfalls, under drains, et cetera, you read on. And at the very last sentence there, including applicable water management district in a manner not to create a nuisance. And so this is in our land development code. This gives us the authority to do code enforcement on systems that are not being operated or maintained correctly. Getting into the code enforcement case, there are three general categories of code enforcement cases regarding stormwater. Generally, it's determining one is the operation and maintenance entity. Who owns it? And I think the magistrate at that particular time was very clear that that's his responsibility, is determining who owns and responsible to maintain the stormwater pipes. The second is obviously the operation of the stormwater system. Are there problems? Is there lack maintenance? Are they leaking? Are they broken? Do they cause a significant risk to the area? And so, yes, that has to be determined. And then generally there's a remedy, and the magistrate determines, once he determines responsibility, he assigns that responsibility to repair. He also assigns a time frame to get that repaired, and he also assigns fines if you don't repair it by a specific time frame. So these are the 6 code enforcement cases that are the DeBary Plantation Community Association that the city has. The first one was Hickory Stick. Remember, as we said, we presented to the DeBary Plantation Community Association in August of 2021 the responsibility that they had of Hickory Stick. We sent 3 or 4 demand letters over the next year or so, and then we did a code enforcement case. They came forward, wanted to discuss it. We have extended those code enforcement cases, those hearings. I extended the hearings because they were making progress. St. John's Water Management District got involved in June of 2023 and ultimately convinced the DeBary Plantation Community Association that they were responsible for Hickory Stick. They signed a consent order in January of 2024, and that construction is going on right now. They're very close to completion for the Hickory Stick. They assessed their residents for Hickory Stick, I believe, was $325, as I understand, and that project is cost somewhere around $430,000 to fix. So that's that. And then there's now 5 leaks in their community, and generally in their older sections in the front and at Quail Lake. Those are generally their older sections. There are 5 leaks that are causing damage. The highest priority one is Cedarwood and Barclay Court. Cedarwood is, that pipe runs between homes, and so that's why you see that on the top of the list. The pipe runs between those 2 homes about 10 feet from running between those particular homes, and so we'll cover those there. But these are the 6 code enforcement cases that we had with the DeBary Plantation Community Association. You haven't seen these, but these are some of the documents, evidence that have been submitted to during the code enforcement case. Units 4, or in 4 phases, 4, 5, 6, 7A, and 7B. What you see on the right is not a city permit. I'm going to say it again. This is the St. John's Water Management District technical report and permit. You can see very clearly on there that based upon their records, and again, this is between DeBary Plantation Community Association and the St. John's Water Management District, that the Homeowners Association is the operation and maintenance entity. They are responsible for the operation and maintenance of these particular pipes under these particular units or phases in DeBary Plantation. This was submitted to the magistrate, and he based his decision based upon some of these particular documents. Also, you see here is Unit 13, which is known as Quail Lake. And again, this is the permit, St. John's Water Management District Technical Report and Permit. You can see there that the operation and maintenance entity is the DeBary Plantation Community Association. They are fully responsible for the stormwater system at Quail Lake. Let me back up here. I'm sorry. Units 4, 5, 6, 7, and 8, 7B, the 2 leaks are at 217 Cedarwood Court and 100 Barclay Court. The Unit 13, which is Quail Lake, they have two leaks there. It's 552 Quail Woods Court and 496 Quail Hill, which is at the corner of Quail Hill and Quail Lake intersection. This is Unit 16, and Unit 16 is unique. We have a leak at 244 Hazeltine Drive. The sidewalk and the area has collapsed. These pipes and all these, and I'll go them a little bit specifically, are leaking. Sediment is leaking into the pipes, and it's causing an erosion to the particular area there. But this is unique because Hazeltine is in the same phase as Hickory Stick. You can see that in January 2024, the operation and maintenance entity was transferred from the developer to the HOA. It would normally. The DeBary Plantation Community Association Board understands owner, operation, and maintenance entity because they signed this particular document accepting the transfer from the developer to themselves to repair the Hickory Stick project. And so as you can see up there on the very top, the O&M entity is the DeBary Plantation Community Association for Unit 16, which also covers Hickory Stick. So when we talk about the DeBary Plantation Community Association, we talk about the operations and maintenance entity that they own all the systems in the entire subdivision. We've been telling them that for the last 3 years. This is a summary of all the permits in the subdivision. It goes from Units 4 through Unit 21. As you can see there, Unit 4, 5, 6, 7A, and 7B, the operation and maintenance entity based upon the St. Johns River Water Management District records that the HOA is responsible for the operation and maintenance. Unit 7C, 8, 9A, 9B, and 10, the operation and the operation and maintenance entity is the owner, which is the developer, and the HOA is the subsequent entity for that. And as you can see there, Units 11 and 12, DeBary Plantation Community Association. Unit 13, DeBary Plantation Community Association. Units 14 and 15, DeBary Plantation Community Association. Again, these are St. Johns Water Management District records, and they're not city permits. They're St. Johns Water Management District permits. And as you can see, all of them are either DeBary Plantation Community Association. I believe Unit 17A, B, C, D, and E is Westridge. When I was talking to Mr. Parpolato, he confirmed that's Westridge. That's the HOA's responsible. Obviously, it's a private gated community. Even DeBary Country Club Realty is the developer. That will transfer automatically to the HOA. And so as you can see there, every phase, every permit in the DeBary Golf and Country Club or DeBary Plantation, the owner and maintenance entity is DeBary Plantation Community Association. And the City Council has not voted or accepted the operation and maintenance responsibilities for DeBary Plantation. So what did the code enforcement case decide? Obviously, Hickory Stick, that's already done. But the 5 cases were held, hearings were held separately for each one of those individually. And the magistrate consistently found on all 5 that the DeBary Plantation Community Association owns the stormwater system. In his orders, he specifically says that they own the stormwater system. Both engineers for the DeBary Plantation Community Association and the city confirmed that the pipes are leaking and causing surface damage. We have videos showing the leaking. It shows the sediment in the pipes, and both engineers have confirmed that they are indeed leaking and that they are causing damage. That DPCA is responsible for the repair. They're the operation and maintenance entity, and that's in the magistrate's order. And that the first one, that Cedarwood Court, he provided 90 days to fix, and on the rest of them, he had provided 120 days to fix. Each engineer, both for the city and for their DeBary Plantation Community Association, the engineer said that these items could be fixed within 60 to 90 days. The pipes are leaking, yes. The one in Cedarwood, there's an urgent to do that because it's running between homes, but they can be done by lining the pipes, and the engineers have confirmed that they can be lined. Typically, lining pipes, as we said before, and I'm going to use an analogy, it's like calling a plumber. You simply, to fix them, You get them out, they camera the system, they verify the leakage and where the leakings occur. They clean the pipes out. They line the pipes, and typically that particular process can take less than 2 to 3 weeks, and that's both confirms with the engineers on both sides that yes, that can be done. The difficult part may be getting them out there and paying for that particular service. So the magistrate did establish fines. He established the dates they had to be repaired. I'll show you in a minute. And if they don't get done, it's $250 a day per incident, which is each one is separate. And the orders were issued May 30th and June 12th, respectively. May 30th on the first 3, and June 12th on our items 5 and 6. And so any future violations, any future leaks in DeBary Plantation that come from code enforcement, they become a repeat offender, and they are $500 a day if they don't fix them in a due time frame. So we've been working on with the DeBary Plantation on meeting. We had developed, the city had developed an agreement so that we can meet with the board without attorneys. And Mr. Johns, our attorney, sent an email. The agreement was approved by both parties, and Mr. Applegate responded back that they are in agreement with the agreement. But unfortunately, a couple hours later, we received an email showing that they have filed an appeal in circuit court against the code enforcement cases. And so we rescinded that agreement because the agreement is no longer valid. Our attorneys recommended that we do not meet with the board unless we have attorneys present. So we just now, I sent an email out to the board desiring to meet. They've been wanting to meet. So our attorneys are now drafting a new agreement. It was sent out today that we'll be glad to meet only with our attorneys present because of the appeal that's now have been filed. As my understanding with this appeal, they have 70 days to provide their reasoning for their appeal and what their requirements are of the appeal. And so depending on how this case flows, it certainly could be, it could take anywhere from 70 days to 6 months before this appeal is finally heard and finished. So this is the law on the appeal. An aggrieved party, including a local government body, may appeal the final administrative order of a code enforcement board to a circuit court. Such an appeal shall not be a hearing of a de novo, which means they can't add any new additional information, and shall be limited to the appellate review of the record created before the enforcement board. So whatever was submitted to the board, court case is what they're appealing, and an appeal shall be filed within 30 days. And so they were running out of time. They filed an appeal. The DeBary Plantation Community Association position during the code enforcement cases, they were concerned about the notice of violation, that we only gave them 30 days to fix the pipes, which generally our notice of violations for code enforcement is 30 days. And we do that on all code and violations. We did it for Hickory Stick. They came in, we extended it. We didn't want to go to hearing, but in this particular case, they did not. I'll show you in the next slide the chain of communications on each one of these particular projects. So they objected that the notice of violation conflicts with Section 122 of the Florida statutes. Generally, it says that we're supposed to provide reasonable time to fix, and they didn't feel that 30 days was unreasonable. Their objection for each case was to the magistrate, that the magistrate has no jurisdiction because of a violation of Florida statutes, and the magistrate dismissed the objections. And when you see the next table, you can see the reasonings why. And so that was their primary objections. They did want to reserve the right, and I don't know if they can bring it up in an appeal. They wanted to reserve the right to challenge the ownership of the pipes. And so, but they didn't do that. They didn't challenge the ownership of the pipes during the code enforcement. And so based upon the evidence that was provided, the magistrate made the decision based upon the evidence as provided. So this is the timeline and decision-making matrix on each one of these each one of these pipes. We have provided, and some of these are in evidence that we submitted. The PM is the property manager, the CM is the city manager, and the HO is the homeowner. They've had significant informal communications about each one of these leaks prior to the notice of violation. That's columns 1. And we have responses from them that they are denying responsibility to fix these particular pipes. On October the 9th, 2023, submitted into evidence my email to the president and the board explaining that they are responsible for the entire stormwater system and that these leaks need to be fixed. The response from the DeBary Plantation Community Association, and the board was copied on those emails, was that they're not responsible. This is a legal matter. Talk to our attorney. And he responded back on all of those. And so the next day we submitted the notice of violations because now they have required us to talk to their attorneys, and so we decided to go to code enforcement. At that particular time, again, now remember, their major violation is that 30 days is not enough time to fix it. The first hearing was scheduled for January 18th, 2024. They requested an extension. It was granted by the magistrate. They did do in March of 2024, they did a case management hearing to decide how these cases should be heard. They decided that they should be heard individually. They scheduled for May 22nd. And so May 22nd, we had the hearings for Cedarwood Court and Barclay. Understanding that May 22nd now, it's 215 days after the notice of violation. And so on each one of these particular orders, you can see on the hearing date, the last two, Quail Hill and Quail Hill Lake and Hazeltine, those hearings were conducted on 6/6, which are 240 days after the notice of violation. And so the magistrate issued the order on the first three on 5/30, and he gave the first one 90 days. The date of repair shall be August 28th, 2024. That's 90 days from the date of order, and that's 312 days after the notice of violation. I think we've given them plenty of time to fix these repairs. And if they don't fix it by August 28th, 2024, the fines start at $250 a day. On Barclay Court, again, the date of repair required is 9/28/24. He gave them 120 days. So that's, they have, from the notice of violation to fix this item, they have 342 days in order to fix this item. Almost a year since the notice of violation, I believe, and it's plenty of time to fix these particular items. And then as you can see there, as you go down, most of these are 342 days from the notice of violation. The last two are 354 days from the notice of violation. And then the last column on the right is the next compliance hearing to determine whether or not they fix these particular pipes and if they have satisfactorily fixed these pipes. And so those are the next scheduled hearings after those times to make that determination. And so we have given them plenty of time. We've worked with the association as much as we possibly can. We worked with them on Hickory Stick for well over 3 years, trying to get them to understand that they're responsible for those particular projects, and we've done so here. We think we've been extremely fair on trying to get them to take ownership of their pipes and to fix them accordingly. And so one of the things that we're going to be bringing up next week is obviously the budget next week, but on July 15th, I'm responsible to submit the budget. So I wanted to show you what the costs are. And for Hickory Stick, the 3 years that we've been working on Hickory Stick, and Kurt, our city attorneys and his firm, we spent $55,417 on Hickory Stick. Just on the code enforcement cases, the city has spent $99,285 just on the code enforcement cases. And we anticipate, depending on the Circuit Court of Appeal on these code enforcement cases, we expect, depending on how the case goes, between $100,000 to $200,000 in attorney's fees. They have, on their particular side, they have an attorney who's being paid, and then they have an attorney who lives in DeBary Golf and Country Club is working pro bono, as I understand. And so, And so that's how they're limiting the cost there. But both entities are expending a significant amount of attorney dollars, even though it appears that most of the evidence that you see here is significantly that shows that DeBary Plantation Community Association is responsible for their own stormwater system. Understand the process that they've gone through, but this is the update on the code enforcement cases, Mayor and Council, that you're looking for. I know you don't participate in code enforcement, but we wanted to, you inquired and wanted to see the evidence, and this is the evidence there. I know that residents have been calling council members, been talking to council members, been talking to me, wanted to, and this is publicly showing all the evidence that's been provided in the code enforcement cases. The cost that you see here is borne by the city, and obviously all 23,000 residents are paying for these particular costs. And so with that, I'll take questions that you may have. Any extraordinary legal questions you might have, I'm going to have to refer to our city attorney, but I can certainly answer most of those.
Are there any questions, or does this serve as a suitable recap of where we are? Councilmember Pappalardo?
I have a very small question. Is under perhaps DPCA's appeal is successful, I don't suppose that they would have much success in challenging the O&M ownership, because that's what's stipulated by St. John's Water Management District. That's what's documented. What would the possible next course of action by either party be?
I can answer that. If they do, and it was kind of discussed in the code enforcement case. If they are successful in saying our notice of violation letter does conflict with the Florida statutes, then we'll have to start the process all over again. It appears that we will issue again another notice of violation. We may give them longer time to fix it, but if that's indeed they win that's saying we violated the due process by only giving them 30 days to fix it. But you can see there the timelines they've had. We're 8 months past the notice of violations, and these items still haven't been fixed.
So functionally, the problem doesn't go away, obviously. It would just restart the clock to another proceeding.
Yeah, we'd have to start the process all over again.
Councilmember Sell, were you indicating a question? I couldn't tell.
I was just thinking with the 30-day notice, usually there's some wiggle room as if somebody shows progress, they're actually working at the issue, you kind of,
Well, we did that with Hickory Stick. Hickory Stick, I extended the code enforcement 5 times so that we didn't have to go to hearing because they were making progress. And then when St. John's Water Management District got involved, it accelerated that particular process. They were still hesitating, and so St. John's management got involved because that was a permit violation. And not necessarily operation and maintenance. It was a permit violation where the pipe was supposed to be moved during the development process of that particular phase and was not moved. And so that was considered a permit violation, and their compliance section took over that particular project.
Also very concerning that this is going to run into almost October, which puts you right through the heart of hurricane season.
Yeah.
And if I was the homeowner that had a pipe going between my house, I'm pretty sure I would be worried about the situation.
Well, they are. I have talked to the homeowner at 217, and our staff has, at 217 Cedarwood Drive, or Court, I'm sorry. They're very concerned, and they're worried, for sure. We hope and pray that the pipes will stay intact, because when you get hurricane season, the water going through them, it puts stress on the system. It's not going to fix itself, as we explained. It's going to continue to get worse and worse and worse. If those pipes do separate, and between those particular homes, and you have to dig to replace them, the cost goes up exponentially, and it goes up high. You see what some of the costs that you're paying on some of these stormwater projects. the cost of getting repaired goes up exponentially when you have to dig, particularly between two particular homes. These pipes during the code enforcement case are only 10 feet from the homes, and to do those particular things. And so leaking is okay. It's an urgent issue. It's not an emergency issue, but it's an urgent issue that needs to be fixed and be fixed very quickly. We stress that, as the hurricane season comes, that those pipes, even though they may leak, we hope they stay together and doesn't cause any further damage.
Is win, lose, draw, whatever, do we recoup these fees if they're found responsible?
Yeah, there's no provision for attorney's fees recovery unless it's in a statute or it's in a contract, and that's not provided for here. Depending upon the basis of the appeal, which has not been set forth by the lawyers for the association, if it's a frivolous basis for appeal, then that they use, then there may be a basis. But right now, there's no basis under statute or contract for the city to recover its fees, unfortunately.
And the $154,000 is already sunk cost.
Yeah.
Is there any other comment, Vice Mayor Butland?
Thank you, Mayor. Do they set an appeal? Does the clock stop at that point until or these fines keep accumulating as the appeals in process?
It's my understanding that if the city wins the appeal, and let's say it's 6 months later, the fines revert back to the date that it was supposed to be repaired.
So they will have to pay those fines?
Yes.
For those period. That's one way I was going to say, that's one way to recoup, but not admitting that they have this issue, that they're responsible, is overturned by their admission that 30 days is not enough to fix it. If you're admitting that, well, I have to fix it, but 30 days is not enough, that's an admission that you have to fix it, and I don't understand why they're thinking they don't have to fix it.
Okay, well,
But
the good thing is
I'm not
we
gonna
don't
go
have
to the
to settle
courts.
it here
I don't have to solve
tonight.
that, but
Yes.
it just is constantly repeating the same thing over and over again. They don't feel that I don't know. I have property there and I'm concerned about it, so.
Okay. All right, thank you so much for that update, City Manager. City